I didn't even leave town. I've been in town this whole time. Huh? I did. I went to Ashley's office and I told, we got all new doors and windows. I got the punch button locked for the back door. And I always told Marilyn, I said, look, I said, don't ever lock. I said, you don't ever unlock it. Leave it like that. You have to get the button to get in. Nobody will ever sneak up on you. Just at night, click the deadbolt. I said, but don't do it in a day because Ashley still don't have a key yet because we just been busy. I said, I don't either. Couldn't get in. So I just run some errands. Because Marilyn was gone. I couldn't get in her office. So I ran some errands. Then they called me and said Ryan's personalized plates for his Mustang were in. So I go over there. He meets me up there with his girlfriend. And so I told him they were in. He said, well, I'm just going to drive up there right now. We're getting ready to go to lunch. So I walk in with them. They're like, the people in the dealership in Dallas still hasn't done their part to even get the old plates assigned to it, whatever. It's not in my name yet. It's like, what takes so long?
When I bought my car in 40,
yeah,
it took forever. I mean, like the day of my dealer tax expiring, and they said that the
No, this meeting was. Muted. All right, good afternoon, everybody. We're going to go ahead and start taking open announcements on the 1:30 docket. I don't think we have anybody via Zoom. If you're in the courtroom and you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. I'm not going to make your health decision for you. And with that, Ms. Altier.
From this morning's docket, Richard Graham Andrews for arraignment. Here are two cause numbers.
Come on, Mr. Andrews, we probably need to get you out of here anyway with all that coughing you got going on.
Sorry.
All right, this is cause number CR 21-0259 and 0261-392, the state of Texas versus Richard Andrews, and that is set for arraignment. Ms. Altier.
Yes, Your Honor, this is Richard Graham Andrews. His name is spelled correctly on the indictments. He understands the nature of the charges, waived the formal reading, and for the purpose of arraignment, he pleads not guilty to both indictments. And he was not here this morning. He
Oh,
was
I know he
supposed-
wasn't here. I was looking for him.
Yes, Your Honor, I understand. Can you have any warrants lifted or if there were any put in place?
Well, I guess I need to know why he wasn't here. I mean, court started at 9 and it's now 1:30.
The bonds office told me I didn't have one yesterday, and then I talked to her maybe a week ago, and she said when the court case came up, she was gonna have me sign some paperwork and waive it, but discount bail bondsman didn't answer the phone even today. It's going straight to some kind of weird voicemail. It says say
Storage
something
unit?
about-
And I confirmed that. I tried to call the bondsman also.
I don't know what's wrong with their service.
Well, I won't get into that. All right, so since the state's asked, and I'll recall the capious, Mr. Andrews, you did show up and I appreciate your effort in getting here.
Yes, sir.
However, in the future, I'm going to be telling you when your court dates are, so you'll have there'll be no confusion or ambiguity about it.
That'd
Sound
be
fair?
awesome. Thank you.
All right, well, the court deems or notes your pleas of not guilty for purposes of arraignment. Your next two court dates are September the 1st at 1:30 for discovery status, and then again on October the 6th at 1:30 for pretrial. And you don't even have to write that down because we're going to give them to you in writing. And so I will see you back on the 1st at 1:30. Just stay in touch with your attorney. We'll see you there, sir.
Thank you.
You're free to go. You too.
I have nothing further today, ma'am.
Yes, ma'am. Thanks. I thought you were going to be on Zoom.
Well, I got to thinking I felt guilty using Zoom when I could get back.
Ah,
I need it next Wednesday, so.
yes, sir. All right, this is cause number CR 20-0427-392, the state of Texas versus Thomas Fanchulo, and set for status.
And Judge, I've had an opportunity to, on multiple occasions, to speak with Mr. Fanchulo. If we could put this on the trial docket.
Is there an offer?
There is an offer, Your Honor.
And it is
10 years.
10 years deferred, and is he declining that
Yes, sir.
offer? All right, well, then the court, Mr. Fanchulo, I know that Mr. Murphy's probably explained this to you at length, but if you've now rejected that offer, if your case does go to trial and you're found guilty, you can't get it deferred from the court at that time. And I'm sure you understand that.
Yes, I do.
But you're presumed innocent, and I don't presume you any other way. So,
Right.
all right, then the court deemed status is held, and are we going to reset this? So I don't know where you are on the list, what number you are, Mr. Fanchulo? Around 52, but we're back in court and trying cases, so those numbers go pretty quick because people plead out and people have trials, and so you will receive notice when you're to appear back in court, and so just stay in touch with Mr. Murphy and your bondsman, and you'll receive notice soon.
Okay,
Thank
Thank
you.
you, sir.
thank you.
Mr. Mills.
Mr. Page 3, Walter Bryce.
Those pages aren't numbered. not there. All right, this is cause number CR 20-0506 and 0627-392, both styled the state of Texas versus Walter Bryson, and the new one is set for arraignment. Mr. Mills.
Judge, Mr. Bryson's name is spelled correctly in the new indictment. We'll waive formal reading of the indictment. He understands what he's been charged with and plead not guilty.
All right, sir, the court notes your plea of not guilty for purposes of arraignment. Your two next court dates on that case are September the 1st at 1:30 for discovery status, and then again on October the 6th at 1:30 for pretrial. And do we have an offer to wrap all these cases up?
We do, yes, sir.
Okay, you got that offer.
Well, actually, Judge, there's a little, he also has an unindicted possession case that's kind of complicating things. And so I was speaking to Mr. Strong earlier, and we're gonna try to look at
Okay.
that and see, but we're, so if we could move this case
Right.
to
On the 20-0506 case, I'll just reset status to September 1 and run them all together. Is that all right with you, Mr. Bryson?
Yes.
All right, that's what we're gonna do then. So we'll see you in September. And if y'all work it out sooner, just contact Kevin.
this next page, I have
David McKee, come on up. This is cause number CR 21-0062-392, the state of Texas versus David McKee, set for status.
So there's been an offer made for state jail time, and Mr. McKee wishes to reject that offer.
All right, and is this a state jail felony?
It is.
Two counts? Okay. All right, well then, Mr. McKee, the court deems status is held. Notes that you've rejected the offer. Your case will be placed on the trial docket, and I don't have a reset notice for you now, but you do need to stay in contact with Mr. Mills and your bondsman, and you'll receive notice soon on when your trial will be. All right, thank you, sir.
Thanks.
And Jesse Webb,
Jesse Webb. Come on up, Mr. Webb. These are cause numbers CR 20-0709 and CR 21-0110-392, both styled state of Texas versus Jesse Webb, and both set for pretrial. Any pretrial from the state?
Standard motion for discovery, Your Honor.
no objection.
Granted. And on behalf of Mr. Webb,
No pretrial, Your Honor. We've received discovery and a plea offer.
and may I see the docket sheet? When the court deems pretrial is held, Mr. Webb, your next court date is August the 5th at 1:30 for status, which is typically your last day to resolve your case before it ends up on the trial docket. All right, sir, so as soon as you receive your reset, you're free to go. Sir.
I think that's all I have on the docket.
Yes, sir.
Thank you.
It's Paul Haber.
Daryl Menifee on page 2, Your Honor.
Mr. Menifee, come on up. These are cause numbers CR 20-0694 and 0695-392, both styled the state of Texas versus Daryl Menifee, and both set for status.
Your Honor, I filed a motion to strike alternative manner and means of assault to peace officer case. asking this court to amend the indictment.
See the indictment.
I don't have it.
It's all right.
I even just went back to my email, typed in his name.
It's not a true amendment, but.
Yeah.
I mean, looking at the indictment, it looks like you have a by punching and spitting, and you just want to amend it to by punching.
That's correct.
Either one of those in and of itself would be
Its own offense.
its own
And
offense. So,
we've since taken the spitting case to grand jury and it was true though. We don't have a cause number yet, but that case was true.
are you on agreement to this, or do we need to, you said you hadn't got it?
She says she hasn't had service.
I think I didn't get service of it, and my request, Your Honor, if the new case was just true build, could we set this case to be heard at the same time as arraignment on that case?
Sure.
And we may consolidate that as well.
So if you want a motion to, or we will set this motion to amend the indictment on the same day as the arraignment. Or is that when the new arraignment is? Oh, okay. So we will reset both of these cases, as well as the new case will be set for arraignment on August the 5th at 1:30.
All right.
Oh, I'm sorry, at 9 o'clock, not 1:30. August 5th, 9 a.m.
I'll explain it.
Does he have an offer to wrap everything up?
He did, and that was rejected, so it's currently, it was 10 years.
Okay.
And that's all I have. Maybe excuse.
Yes, ma'am. Thank
Thank
you.
you. See y'all on the 14th. Daryl just come back to adjourn.
Ms. Melantree, yes, ma'am. Doing great. How are you?
Oh, well, I had an opportunity to speak with Ms. Pace yesterday, and what she told me she couldn't be here. But I've had the opportunity also to look at the discovery in the matter. We're still going over the discovery, asking for a short recess so she can come back and we can talk.
Ms. Pace said that she wasn't contacting Ms. Melantree. They're trying to resolve it.
Well, let's call it so we can get her client up there. This is CR 20-0395-173, State of Texas versus Demetrius Moore. Come on up, Mr. Moore. Ms. Pace can't zoom in? I mean, she zoomed in the other day. This is like the 4th or 5th case that they, so Ms. Pace is working on it. And you got Zoom.
Should have known by Zoom,
Well, she zoomed in the first day.
but she told me she wouldn't be here today.
Okay. All right, and so you just want to reset status by
Yes, sir.
agreement? All right, then I'm going to reset this to August the 5th at 1:30.
Thank you, Your Honor.
And we're gonna have to deal with something with Mr. Moore's cases because he's probably tired of coming to court.
He's probably tired as well,
No, I said he's the one tired. I've got to be here anyway.
and I me as well.
Was that at 9 or
1:30.
1:30. Thank you, Your Honor.
Matt, good to see you.
Likewise. Now, big excuse.
Yes, ma'am.
Yes, sir. Thank you.
Thank you.
Mr. Schmidt,
Page 6 and page 9, all together, that's Mary here, John Bearden.
Mary and John Bearden. These are cause numbers CR 20-0630 and 0631-392. Both styled the State of Texas versus Mary Bearden. And then cause numbers CR 20-0628 and 0629-392, both styled the State of Texas versus John Bearden. Both these cases are called together, even though they were represented by different attorneys. And so all of these cases are set for status.
Your Honor, I believe we have an agreement with both sides that will resolve all the felony cases. It's through the county attorney's office. We have permission through their office as well to work these out, but I have to wait for them to.
I thought we did make that same announcement the last time.
No, we were
close.
Okay.
yeah,
We hadn't finalized.
We hadn't gotten.
we were looking for an offense that was suitable, and so they've got to draft the complaint information, file it, and we'll set it for a plea.
Okay. All right. Well, then what I'll do is I'll reset status to August the 5th at 1:30 on all of these. That way, if they're not resolved, we don't lose track of them. And if we don't need a hearing, we don't need a hearing.
Does you want to go a little bit later? Because I mean, I don't know when they'll file them and.
We've got a representative from the county attorney's office right there. I'm sure they move really quick on stuff.
We do, Your Honor.
See, there you go. But I'll give you more time if you need some.
Can we set for September? I mean, that way it's.
September
in case
1st.
it's-
I think we're more likely to have resolved the case by September than we would August.
Yeah.
September 2nd.
September 2nd, 1:30.
Great.
That better,
That'd be great.
Thank you, Judge.
sir?
We explained it in the statement.
Yeah, if we don't need the hearing, then we'll just take it off the docket. And so as soon as y'all receive the resets, you're free to go. And we may or may not see you on September 2nd.
You will. Gotta be excused, that's all. I have.
Yes, sir. See you.
Bye.
Mr. Green.
Judge Albus Waters.
Let's see the docket sheet. All right, this is cause number CR 21-0025-392, the state of Texas versus Albus Waters. And set for pretrial, any pretrial from the state.
Yes, Your Honor, standard motion.
No objections, Judge.
Right, granted, and on behalf of Mr. Waters,
Judge, I haven't filed my motion to suppress yet. I did inform Mr. Strong I would be filing one and should have it filed by tomorrow.
Okay.
I visited with Mr. Inslee. He had August the 9th at 1:30.
August 9th, 1:30. Okay. All right, well then, the court will set this for a pretrial motion to suppress on August the 9th at 1:30. And then let's see, looks like in May, I drug tested Mr. Waters. He tested positive for meth, put him on conditions of bond. And in June.
He
guess
was
it sick.
ill, but he was,
That's right, he was out there.
yes, sir.
Yeah, and then I set pretrial for today, and he was to show up at 9 a.m. on the 4th of June to take a drug test. Did he ever do that?
It was the day after.
It was 2 days after.
2 days after.
Do we have the results of that? Oh, yeah.
I haven't.
All right, well, I'm gonna order you to take a drug test today, Mr. Waters. When you get done, come back in the courtroom. We'll go over the results together. Yes, sir. And you said you did go there on the 4th?
Yes, sir. I thought it was the day after the court deal, but yes, sir.
Oh,
I did go
okay. Well, we'll just take another one and see where it
there. Passed
comes
it
up.
then.
Gotcha.
Thank you, Judge.
Yes, sir. Vandenberg?
Jeffrey Howard, Judge. He's outside as well.
Oh, okay, I see. He's gonna do this. Now let me see the docket sheet. All right, this is cause number CR 21-0040-392, the state of Texas versus Jeffrey Howard, and set for pretrial. Any pretrial from the state?
Standard motion for discovery, Your Honor.
No objections, Judge.
Granted, and on behalf of Mr. Howard.
None, no.
All right, well then, Mr. Howard, the court deems pretrial is held, and your next court date is August the 5th at 1:30. And so as soon as you receive your reset notice, you're free to go, sir. We'll see you in August
All right.
for status.
Judge is still working on the rest of mine.
Okay. All right. Anything else, Freddie? Not, I'm going to call through the docket. Then if you hear your name, just let me know that you're here. Amanda Burge. Gotcha. Cheryl Franco.
Judge, since this morning, Mr. Strong and I and Ms. Franco have recently agreed that we'll work on the day.
Yes, sir. Ronnie Gilmore. Gotcha. Mr. Green's working on it. Holly Goff. Okay. Jennifer Vandiver. Gotcha. Jeremy Jackson. Okay. Marty Matthews.
Yeah.
Matthew McNair. Gerald Henderson. Gotcha. June Howell. June Howell. Okay. James Kuykendall. Scott McDowell. Robert Hokut. Okay. Taylor Walker. And then Mark Negrete. Cause number CR 21-0580-392, the state of Texas versus Mark Negrete. All right, is there a Mark Negrete in the courtroom? I see no one. I hear no answer. His attorney called, said he would be here this afternoon, requested us to put it on the docket, and neither Mr. Key nor Mr. Negrete are here. And oh, did you? I'm sorry, Negrete. Okay.
She's in custody.
Taylor Walker's in custody. Mark Negrete. I know. So I want to put it on the record that Mr. Key said that they would be here, and they're still not here. All right, well, previously the court had issued a capias and a no bond, and that will remain even if Mr. Negrete, well, I guess I'll hear their answer, but it'll stay a no bond unless and until we hear from Mr. Negrete. That's it. Yes, sir. Mr. Head?
We are ready on Jeremy French. When I say we're ready, we're set for pre-trial, but we've actually reached an agreement.
Sure, you need to get it.
Prosecutor may not have had time.
That's
to
fine.
sign paperwork back to the clerk, so.
I'm here all day. I don't mind. Matthew McNair. Is that the one you want to do first? or-
That's fine.
Okay. First one I saw when I started flipping.
Yes.
All right, these are cause numbers CR 20-0319 and 0664-392. Both styled the state of Texas versus Matthew McNair and both set forth status.
Judge, we're not miles apart, but we don't have anything in stone yet. And if, I was gonna ask for another status, but if it needs to be put on the trial docket.
In the old days, I'd say you get one status, but post-COVID, it's new world. But what's the offer?
The offer right now is 30.
Okay. Can I see the indictment? Is this habitual? Is it
Yes.
alleged? Okay,
Yeah.
I don't need to see it then. Okay. All right, and so I'm sure, and I know you explained to Mr. Steele that if he does go to trial and only if he's found guilty, then the punishment range would, and the two enhancement paragraphs were found true. You understand the punishment range would be 25 to 99 or life. I'm sure he explained that to you. But, okay, well then I'll just give you all one more status, August 5th at 1:30.
Thank you, Judge.
Sure. Marty Matthews.
Yes.
Marty Matthews, come on up, sir. All right, this is cause number CR 20-0645-392, the state of Texas versus Marty Matthews, set for status.
Judge, on this one, I think we're really close. Like, I think if you gave us one more status, I really think we could resolve it and maybe set it the same day. And I'm cautiously optimistic we'll resolve it that day.
Right, and is there an offer? She offer now?
Right now, it's state jail
Between,
time and TDC time, but it's on the lower end of TDC time.
okay. And how many, Mr. Matthews, how long has he been in jail?
It's 7 months.
Okay.
Yeah.
So he's got a lot of time built up. All right, well, then I'll reset status to August 5th at 1:30. Is that all right with you, Mr. Matthews? Sounds like y'all are close. All right, we'll see you back on August 5th at 1:30.
Thank you, Judge.
Sir.
Okay. Thank you.
I think that's it for me, Judge.
Yes, sir. Good to see you.
Thank you. Good to see you.
Well, we're not moving very many cases, but it sounds like we've got some work going on. Yes, we do put it on a trial docket, never give them a date to show back up.
No good.
You ready? All right, we'll go ahead and continue to take open announcements on the 1:30 docket. Mr. Green?
Jennifer Vandiver.
Jennifer Vandiver. All right, this is cause number CR 20-0570-392, the state of Texas versus Jennifer Vandiver. Excuse me, set for status. Where are we at?
Judge, we have an agreement worked out with the state for a pretrial diversion. Ms. Palmer has agreed to waive the pretrial diversion fee, but Ms. Vandiver will be required to pay $365 for the court cost at the time of the plea or the agreement, whatever the proper terminology is for that. And she just needs about a month to get that money together so she can pay that. She's currently unemployed. It's going to take her a little bit of time.
No, is this a confirmation of something we sent off? Can I see
Yes,
the document?
from last time, Judge.
Was this her first time?
I
No.
don't recall. I don't think it was, Judge.
All right, so it looks like in December of 2020, she's positive for methamphetamine, amphetamine, and THC. And then in the COVID. In June, y'all are working on a PTI. I ordered you a.
That was then, yes.
Oh, that's
Yes.
the same one.
Yes,
Okay.
yes, sir.
She said she was in an RV with someone that was doing drugs. So we sent it for confirmation. It's confirmed that it's positive for THC, codeine, methamphetamine, and amphetamine. And so I guess,
Judge, and just for your knowledge, Miss Vandiver did email someone at probation the prescription for the codeine.
what about a prescription for THC and meth?
Judge, I think she testified that.
Right. I mean, I guess the issue is if she's already signed the contract.
We can't do it until we have the money.
But
I
she's
mean-
out on bond and she's positive.
I understand, Judge.
What the state want to do?
Judge, I mean, I think that was the position. Well, I can't speak for Mr. Strong and Ms. Coates,
Right.
but I think that was the position that we were in last time is.
I mean, we're trying to give her a chance to do this PTI, but we also need her to stay clean, so. The issue we're running.
Trying to, because this PTI is so new, and we never did them before, and this is probably only my fourth or fifth one. Were they filing waivers of jury and then
No.
they weren't?
They're doing a waiver jury once they're accepted.
Oh, okay.
Has she been accepted?
No, she has to pay upfront in order to,
Other than the
Apply.
money, has she been accepted?
well, that's part of the application. She can't send in the application to be accepted until she pays the money.
And I can tell the court, I don't see that there would be anything that would disqualify her from it. But obviously, well.
Now, here's what I'm gonna do. I'm gonna drug test her today. And so Ms. Vandiver, I'm gonna drug test you. The court will deem status as held. Actually, I'm gonna reset status to August 5th at 1:30, but I am gonna drug test you today. So you'll go with probation, take the test, when you get done, come back in the courtroom and go over the results together. And whether it's negative or positive, I still don't know what I'm gonna do yet. So what you got?
Holly Goff, Judge.
Holly Goff.
Ms. Goff may be outside. Should be on the bench.
Well, she should be able to hear me.
Judge.
She should be able to hear me.
Oh. That they want to go up the volume went up.
You got the volume turned down? All right, this is cause number CR 20-0447-392, the state of Texas versus Holly Goff, set for status.
Judge, state has conveyed an offer of a 2-year state jail sentence probated for 4 years. We are inclined to accept that. However, Ms. Goff is on parole. We just need to make sure that that's not going to cause any problems
Okay. I can see the documents.
with her parole if we accept that offer. So we just talked to Ms. Coates and she's not opposed to the court resetting it. So allow Ms. Goff to do that.
She tested a negative in May. You just want me to reset it? To
Yes, sir.
August? All right, I'm gonna reset it August 5th at 1:30, Ms. Goff. You tested clean back in May, so I'm not gonna test you today.
And just a reminder, of course, she's on parole and she actually.
Figure she's drug testing over there.
She's on electronic monitoring as well. So
Okay.
she's doing well.
All righty, well, good. All right, Ms. Goff, we will see you on August 5th at 1:30.
Judge, I have a plea ready on Cheryl Franco.
Cheryl Franco. Mr. Negri. Where's your attorney, sir? You don't know? Did he call you and tell you to be here? All right, I need you to have a seat in the jury box. Is he showing that? You have a warrant from the 173rd. Oh, this, okay. Let's have him have a seat there and we'll figure it out. Is it 2 pleas or 1?
It's 1 plea, Judge.
Okay. All right.
On the possession of control substance case.
This is cause number CR 21-0213-392, the state of Texas versus Cheryl Franco. Ms. Franco was brought over after arraignment this morning and a plea has been presented to the court. Is the state ready? And on behalf of Ms. Franco.
We're ready, Your Honor.
All right, ma'am, is your name Cheryl Marie Franco?
Yes, sir, it is.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
If I can get you to raise your right hand the best you can, please. You solemnly swear or affirm testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And lower your hand. Ms. Franco, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand?
Yes, sir.
And Ms. Franco, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on here today?
Yes, sir.
Mr. Green, you believe your client is competent?
I do, Your Honor.
And the court finds that she is competent. Ms. Franco, I know that you were arraigned this morning on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days and up to 2 years in a state jail facility and a fine up to $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that in exchange for your guilty plea, the state is recommending that the court convict you of a lesser included offense of attempted possession of a controlled substance, which is a Class A misdemeanor. And that carries a punishment range of up to 1 year in the county jail and a fine of up to $4,000. Do you understand that range of punishment?
Yes, sir.
In the plea bargain?
Thank you, Judge. The agreement is for 60 days county jail with credit for 60 days on that attempted possession of Class A misdemeanor, plus attorney's fees, court cost, and $180 restitution.
And the bail jumping, y'all are straight up dismissing that,
That's
not
correct.
related to the plea?
That's correct.
Okay. All right, is that your understanding of the plea bargain, Ms. Franco?
Yes, sir.
Is that your understanding, Mr. Green?
It is, Your Honor.
Ms. Franco, a few minutes ago, you told me you could read and write the English language. I'm going to go over two documents with you. The first is the agreed plea recommendation.
Yes, sir.
Did you read and go over both the front and the back of that with Mr. Green?
Yes, sir, I did.
And did you sign them?
Yes, sir, I did.
Do you have any questions about it?
No, sir.
The next document I want to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr.
Yes,
Green?
sir.
And did you sign the second page?
Yes, sir.
Do you have any questions about it?
No, sir, I did.
Do you have any questions about any of the documents that you read and went over with Mr. Green?
No, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
You want to do this plea bargain?
Yes, sir.
And I'll ask you, ma'am, how do you plead to the lesser included offense of attempted possession of a controlled substance, a Class A misdemeanor?
Guilty.
Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason? I hear the evidence.
Thank you, Judge. State offers states 1, states 2, and states 3 in evidence.
No objections, Your Honor.
And I've shown these to offense. 1 is the offense report, 2 is the Morton discovery, 3 is the lab report.
Admitted.
Nothing further by the state.
Rest and close, Your Honor.
All right, Ms. Franco, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of the attempted possession of a controlled substance, a Class A misdemeanor. The court will follow the plea bargain, sentences you to 60 days in the Henderson County Jail. However, you do have credit for 60 days and orders you to pay your attorney's fees, court cost, and lab fee. And let's see, Ms. Franco, does she have any other holds?
She does not.
Okay, and if I sign a release?
There should be one in there, Judge.
Let me make sure that, oh, there it is right there. All right, ma'am. And before you go then, have you had an opportunity to review the judgment in your case?
Yes.
Is your name, the charge, and the time credit correct?
Yes.
All right, ma'am, you need to see Mr. Halbert to your right to be printed and still got to go back to the jail to book you out.
Judge have a plea worked out, ready on Ronnie Gilmore.
Okay. Ronnie Gilmore, come on up, sir. That's what Mr. Green's doing that one. Sorry? We'll find out in a minute. Probation officers. All right, this cause number CR 21-0060-392. The state of Texas versus Ronnie Gilmore set for pretrial today. However, a plea on count 3 of the indictment against Mr. Gilmore in that cause has been presented to the court. Is the state ready?
Yes, Your Honor, state.
And on behalf of Mr. Gilmore,
We're ready, Your Honor.
sir, is your name Ronnie Gilmore? And are you the same person that was originally indicted by Henderson County Grand Jury in count 3 of that cause number for the 3rd-degree felony offense of tampering with or fabricating evidence? And get you to raise your right hand the best you can, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Mr. Gilmore, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that? Yes. You have to answer out loud. She has to take it down. And Mr. Gilmore, have you ever been treated for any mental health or emotional issues? And what would those be?
I have bipolar, paranoid schizophrenia, and manic depression.
Okay, are you on medication for that?
They just took me off on medication to make me nauseated, and I put it in a bowl, and they come in and done a shakedown and took my medication from me. And I'm on my medication right now. I need to be back on it.
Okay, so you put your medication in a bowl?
Yeah, I was gonna give it to the head nurse when she comes around that evening to let her know that it was making me nauseated.
Oh,
They
okay.
came in on the surprise shakedown and got it.
Yeah.
Give it back to her.
Guess that's between you and the jail, but let me just ask you this. Do you understand what's going on in here today?
Yes.
And Mr. Green, do you believe your client is competent?
Judge, I've spoken to Mr. Gilmore many times. I've had no doubt he's competent.
Well, Mr. Gilmore, even though you told me you're having this issue with the jail and your medication, and you've had these diagnoses, the law presumes that you're competent, and I find no reason to find that you're not based upon your demeanor, your answers to my questions, and your attorney's statement, so I find you competent. Mr. Gilmore, I know that you've been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the court? But do you understand the charge?
Yes, sir.
Well, count 3 of that indictment charges you with a 3rd-degree felony. A 3rd-degree felony carries a punishment range. Is it count 3, paragraph A? Is that what we're doing?
That's correct.
Okay, it carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine up to $10,000. Do you understand the range of punishment?
Yes, sir.
And then does he have enhancement paragraphs?
And we're gonna abandon that, but it is in the-
So, and then Mr. Gilmore, if you were to go to trial on this case and be found guilty beyond a reasonable doubt and at the punishment phase, if the jury or the court found the enhancement paragraph true, then the punishment range would be not less than 2 years, no more than 20 years in TDC and a fine of $10,000. So you understand the punishment range in the plea bargain?
Yes, Your Honor, and we are going to abandon enhancement. We're going forward on paragraph 3, or I'm sorry, count 3, paragraph 8. The agreement is for 6 years TDC. We'll ask the court to take into consideration count 1 and count 2 and an unfiled possession of controlled substance felony, plus attorney's fees, court cost, and $180 in restitution.
All right, is that your understanding of the plea bargain, Mr. Gilmore?
Yes, sir.
Is that your understanding, Mr. Green?
It is, Your Honor.
Well, Mr. Gilmore, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents here. The first is the agreed plea recommendation. Did you read and go over both the front? Well, you know, wait for me to answer the question or ask the question before you answer it. Did you read and go over the front and the back with Mr. Green?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions? The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Green?
Yes, sir.
And did you sign that second page there?
Yes, sir.
Do you have any questions about it? Do you have any questions about any of the documents you read and went over with Mr. Green? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No,
Do you want to do this plea bargain?
yes, this is the one.
Then I'll ask you, sir, how do you plead to that 3rd-degree felony offense contained within count 3, paragraph A of the indictment? Are you guilty or not guilty?
So be guilty.
You guess you'd be guilty.
I'm guilty.
I didn't ask you to guess. Are you
I'm
guilty or not guilty?
I'm guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
State offers states 1 and states 2. States 1 is the offense report, and 2 is more discovery compliance, and I've shown these to Mr. Green.
No objection, Your Honor.
Admitted.
Nothing further, rest and close by the state.
Rest of closure, Your Honor.
All right, then, Mr. Gilmore, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that 3rd-degree felony offense in count 3, paragraph A of the indictment. The court has granted the state's motion to abandon the enhancement paragraph. The court has taken into consideration the 2 other counts of the indictment in an unindicted PCS and sentences you to 6 years in the Texas Department of Criminal Justice with credit for 220 days and orders you to pay your attorney's fees, court costs, and lab fee. And Mr. Gilmore, before you go, have you had an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
Did you see it, Mr. Green?
I did, Judge.
And then now, sir, that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult with an attorney. And you're now remanded back to the custody of the sheriff for transport to TDC. Good luck to you, sir. Need to see Mr. Halbert to your right.
That's all my business as of now, Judge.
Yes, sir. Appreciate you. Mr. Stevens.
7, Harold Henderson.
What are we doing, Mr. Henderson?
Status as placed on trial docket. Your Honor.
All right, it's cause number CR 20-0044-392, the state of Texas versus Gerald Henderson, set for status. Where are we at?
Your Honor, that we had an offer of 10 years. I believe it's been rejected.
That's correct, Your Honor.
May I see the indictment, please? Thank you. Okay. It's a second degree.
Yes, Your Honor.
Is there any Brooks notices or anything?
There will be.
What does the state believe that the Brooks notice would do to the punishment range?
It's going to make it a 25 to life, Your Honor.
Okay. All right, and so I'm sure that Mr. Stevens went over that with you, Mr. Henderson, but the offer's 10 years, and I don't presume you anything other than innocent as you stand there, because you are as you stand there under the law. But if you were to go to trial, if you were to be found guilty, and if at punishment, the state were to prove 2 of these enhancement paragraphs that they intend to file true, the punishment range would be not less than 25 years, no more than 99 years or life. And I'm sure Mr. Stevens explained that to you. And so where is he on the list? Okay, so he's pretty far up there.
He's gonna be close, maybe in August.
Okay, so he could get a trial as soon as August.
Could be so.
Okay, all right, then, Mr. Henderson, the court deemed status is held, notes that you rejected the 10-year offer, and will place the case on the trial docket. Are we going to give him a notice of setting? All right, and so you'll receive another notice of setting on when your trial will be. Thank you, sir.
We can work down the list here. I'm ready on all of them, Your Honor.
June Howell,
That'll be a fleet.
come on up, ma'am. You ready, Sherry? You ready on June? All right, this is cause number CR 21-0050-392, the state of Texas versus June Howe. And that is set for set for a plea today. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Howe,
We're ready.
all right, ma'am, is your name June Ellen Howe?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the 3rd-degree felony offense of possession of a controlled substance? I can get you to raise your right hand the best you can, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. And you can lower your hand. Ms. Howe, can you read and write the English language?
Yes,
Are you a U.S. citizen?
yes.
State you missed one on the front end of that one. If it turns out you're not a U.S. citizen and you enter into this plea bargain with the state, certain negative immigration consequences can happen. Do you understand that? And Ms. Howe, have you ever been treated for any mental health or emotional issues? Sorry?
No,
Do you understand what's going on in here?
yes,
And Mr. Stevens, do you believe your client is competent?
I do, Your Honor.
And the court finds that she is competent. Ms. Howe, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
no, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted originally, that charge is a 3rd-degree felony. A 3rd-degree felony carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine up to $10,000. Do you understand the range of punishment?
Yes, sir.
In the plea bargain?
The state is recommending that we go to a lesser included of PCS, a penalty group 1, less than 1 gram. And then under 1244A, do 40 days confinement in Henderson County Jail. $750 fine, $305 court costs, and $180 left.
All right, well, ma'am, let me back up here a little bit. the punishment range for a state jail felony is not less than 180 days nor more than 2 years in a state jail facility and a fine up to $10,000. You understand that range?
Yes, sir.
And then further, under 1244A of our penal code would make this a state jail conviction, but punished as a Class A misdemeanor, which carries up to 1 year in the county jail and a fine up to $4,000. You understand that range?
Yes, sir.
I got to go over by law the ranges of punishment with you. Now, is that your understanding of the plea bargain? And is that your understanding, Mr. Stevens?
Yes, sir.
All right, well, Ms. Howe, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Stevens?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Stevens?
Yes, sir.
And did you sign the second page?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents that you read and went over with Mr. Stevens?
Yes, sir.
Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes, sir.
Do you want to enter into this plea bargain?
Yes, sir.
Then I'll ask you, ma'am, how do you plead to the lesser included offense of that which is charged in the indictment, that state jail felony, possession of a controlled substance, punished as a Class A misdemeanor under 1244A? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
The state offers 3 pieces of evidence. The first is an offense report, the second is an inventory report, and the third is a lab report.
No objections.
All 3 are admitted.
State motion to close the term.
And Your Honor, if I may briefly call my client,
Sure.
please state your name for the record.
Gmail.
And we have been working on your case for quite a while. Is that correct?
Yes, sir.
And we had another offer on the table that was for a deferred probation offer. Is that correct?
Yes, sir.
And it's my understanding you don't have any prior felony criminal history. Is that correct?
No.
And you understand that we talked about what would be required on probation. And you had some concerns based off the amount of cost and the things associated with probation that you may not be successful. Is that correct?
Correct.
And I went back and we negotiated this alternative resolution, which would not require you to be placed on probation. Is that correct?
Correct.
And you understand the downside of this is that it will result in a felony being placed on your criminal history. Is that correct?
Yes, sir.
And knowing all of that, this is what you wanted to do. Is that correct?
Yes, sir.
And knowing that this will still go on your record as a felony, you still want to proceed forward. Is that correct?
Yes, sir.
And are you satisfied with my representation?
Yes, sir.
I'll pass the witness.
Anything from the state?
No question, Chairman.
All right,
We rest and
close.
close.
All right, then, Ms. Howell, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, the state jail felony. The court will follow the plea bargain, sentences you under 1244A of our penal code to 40 days in the Henderson County Jail with credit for 2, and orders you to pay your attorney's fees, court costs, and lab fee. And is she going into custody today?
Yes, sir.
Okay, I think you probably said that. And before you go, Ms. Howe, have you had an opportunity to review the judgment in your case?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, ma'am, and now that you have been convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions, consult with an attorney. You're now remanded to the jail to serve out your sentence. Good luck to you. But you need to see Mr. Halbert before you have a seat.
Working on the list, Your Honor.
Kuykendall,
Yes, sir.
what are we doing with this one?
Place it on the trial docket.
Mr. Kuykendall. Where would he be on the trial docket? These are cause numbers CR 21-0045, 46, and 47-392. All 3 styled the state of Texas versus James Kuykendall, and all set for status.
Yes, Your Honor, an offer to wrap them all up is 10 years. I believe at this time, Mr. Stevens has provided some additional information that he wants me to look into.
Want to just reset it?
Yeah, if we could do one more status, the alleged victim's his mother. She appeared today and kind of talked with me about the allegations, which may dramatically change this case. And I think the state's going to follow up with her on that. And we've presented a resolution that may resolve it. So there's still a chance that it gets resolved, but I think she's willing to talk to the state about that. I mean, talk to the alleged victim about that.
You all right with that, Mr. Kuykendall? Yes. You're the one in jail. All right, then I'm going to reset your status to August the 5th at 1:30.
I'd just like to say thank you.
Yes, sir, you're welcome. And as soon as you receive the reset, you can have a seat.
Yes, sir. Thank you.
And then place on the trial docket on the next one, Your Honor.
Scott McDowell. This is cause number CR 19-0314-392, the state of Texas versus Scott McDowell, set for status. Where are we at?
Your Honor, this is the one where he was to come for a plea and he didn't show up. It was said on the jury trial docket.
There's been a new offer, there's a waiver of jury trial.
Yeah.
There is a new offer. We had presented to the court. I think he had called the court coordinator that morning, was advised that he had a fever, was going to the doctor. I think they basically probably told him, you better have some documentation from the doctor. He did go to UT Health, presented himself there with symptoms of fever. They then sent him to the clinic or the pharmacy that does the free COVID testing. He went and did that. I think we provided that information at court, but I think his bond got forfeited. Because of that, the offer was rejected, but I've
Rejected or
shown
revoked?
them, or I guess
They
rescinded.
revoked it.
They
Okay.
revoked it.
Okay.
So then it plays into question, well, we had a jury waiver on file based on that plea recommendation, but I did show them the records of the UT Health. I don't know if that's going to then change their position because my client's still willing to accept the original offer, but
Was he positive for COVID or just?
he was not positive for COVID, but he did have a fever and I think was prescribed medication for that, for a viral infection.
Okay.
And I have those records if the court wants to look at them. But I was also going to be setting a motion to either reduce or set bond if he's held on a no bond based on presenting that documentation to the court that he did follow through with the requirements, went and took the COVID test at UT Health, not just some random place.
So hold on a second. So he filed a jury waiver. I'm trying to remember this. He filed a jury waiver and he was to show up for a bench trial?
For the plea, Your Honor.
For a plea. Okay, I got you.
And then the day of the plea, he called sick. I think he called the court first. Court said, need documentation, called my office. We said, go to the hospital, provide us documentation. And then he did provide that he did go to UT Health.
What's the offer now?
Offers 10 years, Your Honor.
What was it before?
3. And that was because of the prior administration. Just going to,
You were honoring the prior administration's offer.
yes, Your Honor.
Okay. I can't make them offer you anything. Not the way it works, separation of powers. I just get to, well, the thing about the jury waivers though, Mr. Stevens, is I bet if I went and looked back at the record, I would have told him, I usually do, that even if the deal falls through, that they've waived their constitutional right to a trial by jury.
And I think we may need to check the record on it and whether or not we stated that waiver is based on the entering of the police. I think we may ask to go back and look at that record because if the state and I agreed that the waiver is based on the 3-year offer and then they pull that offer for whatever reason they decide to change their mind, then I think we then have the option to change our mind at that point. If our plea agreement was
There is
based on
case
that.
law on it. It's just been years since I do it. Typically, you file the jury waiver so you're not made to go to trial because you have a plea worked out that you're going to do later on. I mean, that's typically all of them. Very few of them are filed because they actually want a bench trial.
And this one was because of plea, that we had a plea worked out.
No, but even then, I think there's case law that there's only, I mean, I can,
Unless they're detrimental, which would
Yeah.
be hard to prove.
how did I know that you would know what the case law was?
But I mean, obviously, we could not recess that case, and in order to lock in the 3-year deal, there was a bargain to
Oh, I
waive
know.
our right to jury. So I think there is detrimental reliance that we stated we were going to accept the offer. Had he been here that morning, we would have entered the plea. He did present himself for the testing and did as was told. And
Yeah, I'm
now the
kind
state's
of,
pulled the offer.
I'm
So
kind of siding with you. And that's why I said, I mean, it sounds like he did, at least from what you're telling me, he did what he was asked to do. I don't want him in here with a fever.
The main issue is it's Mr. Cox's case. He's asking to set it for bench trial, but I get what he's saying.
And
So if we could just reset it.
And I was gonna file a motion to set bond, and I'd already visited with the state that I was gonna email them the UT health records to Danny. So that he could take a look at it. And I told my client, hey, we'll still see if he'll honor it when we come back. But my staff's preparing that motion right now. It's gonna be e-filed. They just filed it, and I think we're gonna see to set it maybe relatively quickly. I'll present that information to Danny. We can take up the bench trial issue, I guess, at that.
And he'll be here.
Okay.
hearing date. We're hopeful we'll still work it out and take that initial offer, and I'm gonna let Danny see the UT records that we sent him to.
I know we spent a lot of time on that, but I'm just trying to understand where we were and what happened. Okay, well then here's what we're gonna do, Mr. McDowell. I'm gonna reset status to,
We do it next week now. And so I think our motion's been filed. We'd ask to have the motion to set bond, and obviously if we have a plea to present,
I'll
that'll
hear
go
it
away.
all right, well then we will reset this July 15th, 9 a.m. for any hearings on bond that are filed, as well as take up any other things we need to take up. Thank you, Mr. McDowell. You can have a seat.
I think they're fixing that reset notice. I'll provide it to my client. And I believe that concludes my business. May I have excuse?
Yes, sir.
Thank you.
Mr. Weiner.
Yes, page 9. Bobby, okay.
Son cut the grass and he said, is the lawnmower quit when it runs out of gas?
Most of the time.
100% of the time.
We are doing the first half of the plea on this today, Judge.
Okay. Just give him down a little bit. We're off the record. So there's two of these. Let's stay off the record for a second.
Yes, Your Honor, there's two sets of paperwork. They both come from the same transaction. There's a burglary habitation that he's going to plead open on, ask the court to defer finding a guilt or a PSI. Same announcement for the aggravated robbery. But there is a nuance that the state is asking the court to be bound, or I'm asking with agreement by the state that the court's bound to 25 or less should you decide that he should go to prison, which obviously.
So we're going to recite that as a term of the plea bargain.
Yes, Your Honor.
Okay.
And waiving his right to jury trial.
Because if I didn't follow that, he could withdraw his guilty plea.
Yes, sir. That's my understanding.
All right. Good. All right, let me call it then. These are, is it 2 counts?
It's just, I believe they're two separate indictments.
I only have one.
Oh, wait, no, there must be 2 counts.
There's one
No,
on the
there are. I
docket.
only have one on the docket.
Okay.
All right, this is cause, or these are cause numbers CR 19-0423 and CR 20-0713-392, both styled the state of Texas versus Robert Marlon Hocutt Jr. And this is set for status today. I'm sorry, no, it's set for a plea today. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Hocutt.
I'm ready, Judge.
Right, sir, is your name Robert Hocutt?
Yes, Your Honor.
And are you the same person that was originally indicted by a Henderson County grand jury in this 0713 case for the first-degree felony offense of aggravated robbery? And are you also the same person that was indicted by a Henderson County grand jury in this 0423 case for the second degree felony offense of burglary of a habitation? So I get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Hocutt, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain, it can have certain negative immigration consequences. You understand that? And Mr. Hocutt, have you ever been treated for any mental health or emotional issues? You haven't? And do you understand what's going on here? And Mr. Weiner, do you believe your client is competent?
I do, Judge.
And the court finds that he is competent. Mr. Hocutt, I know that you've already been arraigned on each of these cases. However, would you like the prosecutor to read the indictments out loud here in the courtroom? But do you understand the charges? Well, as indicted, that aggravated robbery charge is a first-degree felony, which carries a punishment range of not less than 5 years or more than 99 years or life in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
In this second-degree felony, burglary of a habitation, that carries a punishment range of not less than 2 years or more than 20 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargains in each of the cases?
Your Honor, we don't have a plea bargain at this time, but we have agreed to cap it at 20.
Well, there is a plea bargain. Because the plea is that he would go open to the court on punishment with a cap of 25 years
And waive our right to a jury trial. on
and
both
waiving
cases.
his right to a jury trial.
Yes, Your Honor.
But that is the bargain, Judge.
Okay. And so, Mr. Hocutt, let me explain that to you, because I might have confused everybody. You have first of all, you have a right, and I know Mr. Weiner explained it to you, and it's actually in some of these documents I'm going to go over. But if you enter your guilty plea based on this agreement, and if for some reason I don't follow it, in other words, I hear the evidence and sentence you above that 25 years, you can actually withdraw your guilty plea because you didn't bargain for that. So the bargain, as I understand it, is you're going to plead guilty without a jury by waiving your jury to the court. The court is then going to hear the evidence at a sentencing hearing and sentence you. Their recommendation is that I would go less than 25 on any sentence if I sentence you to prison. Do you understand that?
Yes, sir.
And so is that your understanding? And that's for both of these or just the ag robbery?
There's no cap on the Berg cap. It's a cap of 20 by
Okay.
statute, Judge.
Well, it's still a plea bargain because it's conditioned on this other case. So.
And he's waiving his right to a jury trial as
Right.
well.
And so that's your understanding of both of these plea bargains, Mr. Hocutt.
Yes, Your Honor.
And is that your understanding, Mr. Weiner?
It is, Judge.
Well, Mr. Hocutt, a few minutes ago, you told me you could read and write the English language. I'm going to go over a couple documents with you. The first are the agreed plea recommendations. Now, I'm holding one for each case that you're indicted for. Did you read and go over both pages of that, each of these agreed plea recommendations with Mr. Weiner?
Yes, sir. I did.
And did you sign both pages of them?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. There's one for each case. However, they say the same things. The only thing that is different are the cause numbers. Did you read and go over both pages of these documents in each case with your attorney?
Yes, sir.
And did you sign the back pages of it? Do you have any questions about it?
Sir.
Do you have any questions about any of the documents that you read and went over with Mr. Weiner? Well, if you read and went over these, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in any or both of these cases?
Yes, sir.
Do you want to waive your right and enter into these plea bargains with the state?
Yes, sir.
Then I'll ask you, sir, in cause number CR 19-0423-392 to that second degree felony offense of burglary of a habitation, are you guilty or not guilty?
Guilty, Your Honor.
And are you pleading guilty because you are and for no other reason? I'll hear the evidence in that case.
Your Honor, state offer states 1, which is a copy of the offense report, as well as states 2, which is the
Inventory report.
We've previously received review and have no objection to state's office.
Admitted
State rest and closes.
and rest and close in that case as well.
Yes, Your Honor.
All right, and now in cause number CR 20-0713-392, Mr. Hokut to that first degree felony offense of aggravated robbery as charged in the indictment. Are you guilty or not guilty? And are you pleading guilty because you are and for no other reason? I hear the evidence in that case.
Your Honor, state offer states 1, which is a copy of the offense report, as well as states 2, which is a copy of the inventory report.
We've previously received review and have no objection to any of the state's offers.
Admitted.
State rest and closes.
And we rest and close as well on that one, Judge.
All right, Mr. Hokut, based upon your guilty plea and the evidence in the 0423 case, and the court has enough evidence to find you guilty and does find you guilty.
Asking you to defer finding.
Oh, you're asking me to defer?
Yes.
All right, the court has enough evidence to find you guilty. However, the court will defer making a finding and set this for punishment. And let's see, you do have 76 days credit as to any sentence you may eventually have to serve in order for you to pay your court costs. Now, in cause number CR 20-0713-392, Mr. Hokut, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding and set this case for punishment. You have 76 days credit as to any sentence you may eventually have to serve in order for you to pay your court costs in that case. And so we will recess this trial, this bench trial, and set it for punishment and order a PSI. Have I done that yet?
No, I believe the state has forms for the PSI. We don't have a date for punishment yet, Judge. I think half a day.
What day? What time? August 30th. Everybody's talking so soft. August 30th, 1:30. And PSI will be due by August 23rd. And long form, y'all can do that by then? Of course y'all can. All right, so I am signing the order for PSI. And so we will see you back on August 30th. At what time? 1:30. 1:30. Mr. Hokut for punishment.
Thank you, Judge.
Yes, ma'am. Thank
And
you.
I'm sorry you confused me, so.
What's that?
I'm sorry I got confused.
No, though, anytime you do the open plea and is it conditioned on this, that's why I want to make sure on the record it's clear. So now.
Thank you.
You're welcome.
And then, Judge, this is the case that we were asking you to set a bond on so that we could execute a plea. That's really unorthodox. But that way it can get a cause number and it can be
What's the
TIC.
bond on arrest? Probably 8,500 if it's a.
I'm pulling up Taylor Walker.
He from Eustis. Yeah.
Never had a chance. It was either 10,000 or 15,000.
It's a plea for probation anyway. What is this?
It is a plea for probation, yes.
Yes, I knew, I haven't seen her in years. Though.
You just mentioned. What is the
This
indictment?
is the lesson grant, state jail. But it's 8,500 or 10.
No, we had been Chambers back with the previous administration. You'd commented on that before.
I thought I knew that.
Yeah.
I saw her out there. I thought I recognized her. All right. I set $15,000 surety bond. I've
Thanks.
never set a bond on an indictment in court before. It's normally done ex parte.
Is that correct?
All right, what else do we have left? So we've still got Taylor Walker left to do.
Once we have that cause number, we can add it to the plea papers. I'll get her signed up and we're ready for the plea.
Stephen State 113.
It has been crazy. Was he from earlier today? Like this morning? Let me see the docket sheet on. Oh. It was clean too, they said. All right. Yes, ma'am. You have Amanda Burge.
Yeah, number one.
Yep. Well, number 2 and 3 and 4, actually. Ms. Burge, come on up.
3 and 4. I thought we just missed some of them.
What's that?
3 and 4. is that what you
Well,
said?
we brought another person back.
Oh,
So, was this a plea? Let's see. So there's 2, she's pleading on 1. Is that correct?
right. We're just missing, and we're also just missing a misdemeanor. Your Honor.
Good. All right, this is cause number CR 20-0563-173. The state of Texas versus Amanda Jo Burge, and this is set today for status. However, a plea has been presented to the court. Is the state ready? And on behalf of Ms. Burge,
Defense is ready, Your Honor.
all right, ma'am, is your name Amanda Jo Burge?
Yes, Your Honor.
And are you the same person that was originally indicted by Henderson County Grand Jury for this 3rd-degree felony offense of possession of a controlled substance?
Yes, Your Honor.
I'll get you to raise your right hand the best you can. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
You can lower your hand. Ms. Burge, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand it?
Yes, sir.
Ms. Burge, have you ever been treated for any mental health or emotional issues?
No, sir.
Do you understand what's going on in here?
Yes,
Ms. Cummings, you believe your client is competent,
I do, Your Honor.
and the court finds that she is competent. Ms. Burge, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment out loud here in our court?
No, Your Honor.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a 3rd-degree felony, which carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine of up to $10,000. Do you understand the range of punishment?
Yes, Your Honor.
In the plea bargain?
Your Honor, the agreement is for a 4-year deferred probation plus court costs $180 in restitution. And I don't see it on this, but there's a $750 fine.
Correct, Your Honor.
I'll write it down.
Thank you, Judge. Special conditions of that probation are AA and Indian meetings, $50 to Crime Stoppers, analysis testing, 200 community service hours, drug offenders program, and complete substance abuse evaluation of all the recommended treatment. State will ask this court to take into consideration CR 20-0562-173 and an unfiled misdemeanor driving while licensed and valid enhanced.
Is that your understanding of the plea bargain, Ms. Burge?
Yes, Your Honor.
Is that your understanding, Ms.
Yes,
Cummings?
Your
Ms. Burge, a few minutes ago, you told me you could read and write the English language. Got 2 documents I'm going to go over with you. First is the agreed plea recommendation. Did you read and go over both the front and the back of that document with Ms. Cummings?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
And do you have any questions about it?
No, Your Honor.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Ms. Cummings?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with her?
No, sir.
Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
No, sir.
you want to waive your right to a jury trial and do this plea bargain.
Yes.
And I'll ask you, ma'am, how do you plead to that third-degree felony offense of possession of a controlled substance as alleged in the indictment? Are you guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes.
I'll hear the evidence.
Thank you, Judge. State offers states 1, states 2, and states 3. States 1 is the offense report, 2 is more discovery requirements, and 3 is
No objection, Your Honor.
All three are admitted.
nothing further by the state. Rest in peace.
First to close.
All right, Ms. Burge, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defers making any finding, places you on 4 years community supervision. You do have 60 days credit as to any sentence you may eventually have to serve, and orders you to pay your fine, court costs, lab fee, and to abide by all the regular and special terms and conditions of community supervision. And Ms. Burge, have you ever been on probation? All right, well, do you know what can happen to you if you violate any term or condition of this probation? What can happen?
Go to prison.
For how long?
Up to 10 years.
That's right. That's kind of the downside of a deferred. There's always a negative side of a deal if things go wrong. And in this case, if you lost my train of thought, if you violate any term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if the court found it was true at a hearing that you violated even one term or condition, the court could find you guilty, revoke your probation, and that's why I lost my train of thought. You're open to the entire sentencing range.
Yes, sir.
You can be sentenced up to 10 years in TDC, you understand? All right. And let's see, is there anything else? And Ms. Burge, you had that subway in Eustis going and running, and it's falling apart since you left.
I heard about it.
I don't even go in there anymore. And so, good luck to you, ma'am. I really hope that I see you in the subway and not here.
Thank you, Judge. I will be excused.
Yes, ma'am. What else do we have? How about Mr. Waters? Whatever happened to him? Is that that and Miss Vandiver, or those are two last ones? Do you have anything else? Oh, Mr. Negrete. Well, Mr. Negrete, did your attorney call you and tell you to be here? Did he? I'm sorry? No, I understand. How, but where's he at? Did he say he was going to be here? Come on up, Mr. Negrete. That's figure out what we're doing. So he was arrested for something, and then when they indicted him on 2 counts of something. Okay.
So I sent notice.
Well, by law, it has to be sealed until he's arrested.
Yeah, but on the first count, I sent notice on the first count to him or the address that he left on his bond and then his bond company. And then we have that sealed one.
Sealed indictment.
Sealed one.
And that bond was 25,000. And I forfeited his bond on the other. I mean, he's here, so he got here. That's what,
Mr. Key tried to file a waiver while we were having court this morning.
well, it's Mr. Key. So I'll recall, any objection to me recalling the capias for the first count, the one or the first indictment, but you still have a $25,000 bond on the other one. And so I'm going to reset status. There's a status arraignment. I'm going to reset arraignment to August 5th at 9 a.m. on, where do I not have it? That's on both cases?
Well, it's one indictment.
Right, on that one indictment. And so, but you still have the $25,000 bond that was set on the second count. And so you're going to have to stay in custody and arrange to make bond on that one. And then I will see you back here. I don't care if you never talk to Mr. Key again. I need to see you here on August 5th, 9 o'clock, 9 a.m. All right, so now that only leaves us with Mr. Waters and Miss Vanderbilt. He's not going. He's not going to go.
I just asked him, he said, "Oh, it's good work."
And then y'all need to see me. Okay. All right, well, let's take a recess and I'll visit with y'all on that.
I still think you managed to cause them some of the they won't get around. Okay.
It's true. Judge Ken is like walking. Oh. Yeah. But, yeah. Probably the first time. Hey,
Oh, I know that. You do. I just. Still now. Oh, yeah. He's still alive. And we were talking about it already. One time I found out he was watching. Yes, he was watching American. And so I went online, and I never was, and I found out that people die, and I would just like the name of the doors to open. Like, you know, anywhere, like, you know, computer thing, you know, it's like, this was next. And he was, yeah, it was. Yeah, we used to see our conference. Yeah. But no, yeah, I'm just we almost have yeah. Just tell them. Yeah. I'm thinking about that. And so,
Sorry, thank you. Is Marisol still here?
No,
Point somebody in here. Who are you gonna- All right, that's the two, the truth from. Mr. Degree, come on back up here. Where is he at on my docket? How come I keep finding it? Let me see the indictment in that case. Yeah. And so, Mr. Negrete, have you, let me ask you this, Mr. Key, when's the last time you, I'm gonna place you under oath, but I'm not gonna ask you anything other than about your attorney, okay? So you raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. When is the last time you talked with Mr. Key?
He called me Monday and told me I didn't have to be here today in court.
Okay,
He called my mom like 10:45. And so we had to be there at 11. And I was at work. I've been at work since 4.
Where do you work at?
Athens Commission and for Force Brothers. And
Right.
then
And how long have you worked for the Forster brother?
3-4 years.
What do you
My dad's
do?
been-
Move cattle, livestock?
My dad's worked for them forever. I just kind of grew up there.
But do you have any money to hire an attorney besides Mr. Key?
Yes, sir.
You do? Okay. All right, well then, I just wanted to figure it out. So Mr. Key just told you to get to court?
He said I have to come today.
Okay. He said you did, and then he called and said you did. All right, well, I rescinded your other, I just want to get to the bottom of it. I rescinded your other bond forfeiture, but you still have that $25,000 bond to make. So, Mr. You can have a seat. Thank you. Mr. Green?
Judge, Vandiver, she still should be outside the door. Up there and saw, didn't realize that arrow was in the back. This was arrow on the screen. I thought it was in the back of my head. I see something.
Is that why?
I was like, something all over the back of my head. Okay, they make some more hair grow up there.
I don't even want to hear about that. You got no room to talk. All right, this is cause number CR 20-0570-392, the state of Texas versus Jennifer Vandiver. Ms. Vandiver was here for status today. I ordered her to take a drug test, and she has tested positive for methamphetamine. She previously had a test that was sent off and confirmed for meth and THC, as well as codeine, which I hear she's provided a prescription for. However, Ms. Vandiver, I'm going to find your bond insufficient. What is it? Her bond, her current bond? Is that what it currently is, or have I raised it once before?
Never raised
All right,
it.
and so your bond is now $17,000 surety bond. And Ms. Vandiver, I mean, and you admitted to smoking it in June. You need help. And I did talk with Mr. Green, and he's going to try to get you some help. But we can all try and get you help, but you know this. You're the only one that can help yourself.
Judge, as I mentioned, she is, I think, at a point in her life where she realizes and has made the decision herself. And I told her when we last visited a few minutes ago that I'm going to reach out to Senate Court tomorrow and work on getting her in that. And then we'll address what we got to do with the district attorney and the court.
Sure.
To make that happen.
Okay. All right, Ms. Vandiver, you can have a seat. You can have a seat in the jury box.
Judge, I don't know what you want to do on Mr. Waters.
Let's just bring him in. See, has he gone yet? I mean, I've gone twice since I ordered him to go. I'm sorry?
He has gone.
I was hoping they would be short. All right, let me see if I can't find it. Mr. Waters, let's go back on the record. Cause number CR 21-0025-392, the state of Texas versus Alvis Waters. Set for pretrial. Mr. Waters was ordered to take a drug test, and that's been a couple hours ago, I think. And Mr. Green.
Judge, Ms. Waters informed me right after you asked or told him to do that, that he had gone just before he came into court. Just he wasn't expecting to have to take one since he took one last one. So
Can we do this in the morning or?
No, sir.
I mean, I'm doing all I can do, Judge. I mean,
You know, unless you have a medical condition. I mean, typically, if somebody can provide a specimen on queue unless you have some type of medical condition.
I mean, I've never been able to provide one on keys, sir. Even as a child, I had my mother that.
Well, I'm not gonna ask your mother about your urinary habits, but and now the probation is telling me, Mr. Green, that he did not come in or they have no, put it another way, they have no record of him coming in the following day and providing a sample.
We have checked the sign-in sheets, because anytime somebody signs in, especially the UA's report, or whether it being just regular probations, we keep sign-in sheets every day. We have no record of him signing in at any time.
They did not ask me to sign in, sir.
They are asked each time they come in, sign in, and they sign in the front. We also have no record of any UA submitted by the defendant for the month of June.
What else do we have left? Mr. Weiner? All right, Mr. Waters, when I'm finished with this plea, I'm gonna check in where you're at, and if you're not, if you haven't gone by then, I'm gonna consider it a refusal. Plus, I don't have any evidence that you went before, and I'll take it up. So you need to go back out there and try.
We'll try, sir.
Mr. Weiner?
Page 9.
And Mr. Waters has tested positive before.
Sure, speak up. She's thinking of it.
All righty. This is cause number CR 20-0543-392, the state of Texas versus Taylor Walker. Set for status today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Ms. Walker.
We're ready, Judge.
Ma'am, is your name Taylor Denise Walker?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
And get you to raise your right hand the best you can, please. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth to help you God? You can lower your hand. Ms. Walker, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it can have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Ms. Walker, have you ever been treated for any mental health or emotional issues?
Yes, sir.
You understand what's going on in here today?
Yes, sir.
And Mr. Weiner, do you believe your client is competent?
I do, Judge.
And the court finds that she is. Ms. Walker, I know we've already arranged you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
Yes, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony, which carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine up to $10,000. Do you understand the range of punishment
Yes, sir.
in the plea bargain?
Your Honor, we would be taking into consideration one indicted and one unindicted charge and recommending a 3-year deferred adjudication probation with $365 court cost, $180 lab fee times 3 for each of those cases, and all standard and special terms and conditions of probation.
Is that your understanding of the plea bargain, Ms. Walker?
Yes, sir.
Is that your understanding, Mr. Weiner?
It is, Judge.
Well, Ms. Walker, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that with Mr. Weiner?
Yes, sir.
And did you sign the front and the back?
Yes, sir.
Do you have any questions about it?
Yes, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Weiner?
Yes, sir.
And did you sign it?
Yes, sir.
Do you have any questions about it?
Yes, sir.
Do you have any questions about any of the documents that you read and went over with him?
Yes, sir.
Well, if you read and went over those with Mr. Weiner, I know that he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial?
Yes, sir.
You want to do this plea bargain?
Yes, sir.
And I'll ask you, ma'am, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are and for no other reason? We'll hear the evidence.
The state has three pieces of evidence to offer, Your Honor. The first is an offense report, the second is an inventory report, and the third is a lab report.
We previously received, reviewed, and have no objection to state's offers.
Admitted.
State rests and closes, Your Honor.
We rest and close as well, Judge.
All right, Ms. Walker, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will defer making any finding, follow the plea bargain, considers the indicted and unindicted case in sentencing you, places you on 3 years community supervision. You do have 56 days credit as to any sentence you may eventually have to serve, and orders you to pay your court costs, those 3 lab fees, and then to abide by all the regular and special terms and conditions of community supervision. And Ms. Walker, have you ever been on probation? Do you know what can happen to you if you violate any term and condition of this probation? What can happen? For how long? For up to 2 years, you understand? And do you know how state jail time is served? Typically day for day, you understand that? So here's what can happen. If you violate any term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court, and if the court at a hearing found it were true that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years in state jail, you understand? So it's very important you follow these, you understand? All right, good luck to you, man. Is there anything else holding, or did I sign a release?
You did sign a release.
Well, then not only am I waiting for Mr. Waters, but there's people out here waiting to book out that are waiting for Mr. Waters.
That's all I have. Maybe excuse, Judge. Right.
Time to get home.
Watch, big brother.